Greetings! Welcome to episode 3 of the Politics of Prosecution video series. This episode will look at the criminal process. So we started with an introduction. Last episode looked at the government structure. This episode is going to focus on the court process. This will look at the legal considerations that prosecutors must take into account when they're dealing with the court process. And we're going to break this down into 3 basic parts. We're going to begin by looking at this idea of an adversarial process and what do we mean by an adversarial process. The second piece is going to look at sort of a hybrid between the rights that defendants have in criminal cases and how the process operates. What are the steps in that process? Then we're going to finally look at the trial itself. How does a trial operate? What does a trial look like when it occurs? To begin, we're going to start with an analogy. And this analogy comes to us from law professor William Pizzi, who wrote a book about comparing the European criminal court system to the American criminal court system. And he started out his book with this particular analogy, and it went like this. Soccer is to football as European court systems are to the American court systems. Now, his underlying idea here is that the continent's favorite sport connects to the court system because they both derive from the same culture. So in the United States, football being the most popular sport, that is a function of our culture, and therefore our court system is also a function of our culture. They will share some of the same characteristics. The same thing goes for Europe. Soccer is the most popular sport in Europe. It has certain characteristics. The European criminal court system is also going to share those characteristics because it derives from the same culture. So with that as our basic analogy, we need to look and see how that system actually plays out. First, let's look at soccer and the European systems. Soccer as a sport is relatively easy to understand from a rules perspective. Right? There are basically 11 people per side, 10 players out in the field per side, 1 in goal. The idea is to kick the ball or move the ball downfield and get it into the opponent's goal. You can use anything you want to get that ball into that goal other than your hands or arms to do so. Beyond that, you need to keep the ball within bounds. So there's white lines around the outside of the field. You need to keep the ball within that. You can't push the person over. You can't knock the person over to take the ball away from them. But other than that, the rules are relatively simple. The most complicated that it gets is figuring out what offsides is. Offsides is basically if your team has the ball and one of your teammates has it, you have to have one opposing team's player between you and the goalie. Otherwise, you're going to be offsides. And that can be pretty complicated at times to figure out. But beyond that, the rules are not terribly complicated. This allows for a very free-flowing game. There are not many stoppages of play. The clock continues to run 90 minutes, 45-minute halves. There's some added time that's flexible at the end of each half, but for the most part, it is a very player-dominated game, very free-flowing. Contrast that to football. Football also has 11 players on a side. The field size is relatively similar, but how you move the ball downfield, the different ways you move the ball downfield, the different ways that you can score points are all very different. In addition, the players have very specialized in what they can do. People who play on the offensive line don't have the same skill set as people who play out at wide receiver or at quarterback. people play on offense don't have the same skill set as the people who play on defense. There is a lot of starting and stopping. There is very complicated rules when it comes to most everything, right? For example, take throwing the ball downfield, right? The ball must travel downfield. It must be caught. There's questions about what actually a catch looks like and how to define a catch. The receiver must have 2 feet in bounds, or one part of their body must land in bounds. They must control the ball all the way to the ground. Whether or not the defender can touch the receiver or not, and when they can touch the receiver or not, there are very complicated rules about that. They can only be thrown downfield once per play. Can only be thrown to certain people along the way. The people can't run out of bounds and come back in bounds and then touch the ball. Right? It's very complicated in terms of how it works. This leads to a lot of stop and start. It leads to a much longer game. While the game clock is only 60 minutes, it usually takes 3.5, almost 4 hours now to get through an entire game, because the clock starts, the clock stops, there's timeouts, right? And there is much more that goes into it. It is not a player-dominated game. It is a coach-dominated game. Teams spend all week, they spend hundreds of hours in a week preparing for the next game, watching film, planning out what they're going to do every single snap of the game. There's a game plan that goes into it. And it's a very complex, very detail-oriented game. Our court systems are the same way. The European system, much more open and free-flowing. The American system, it takes a lot of time. It's very slow-moving. We can make another comparison as well in terms of the officiating. In soccer, the officials let the players play. Right? It creates more of that flow of the game. It allows players to adapt and improvise and work their way through the game. In addition, there's not a ton of precision. Now, I will say this is changing, and this is a way that American culture is filtering into the game of soccer, but there's not precise measurements that are made, right? Where the ball goes out of bounds, as long as the player throwing the ball back into play is close to where it came out, they're okay. Players, when there's a foul, are supposed to stand 10 yards away from the team who gets the free kick. Right? They used to not measure that in detail. Right? As long as it's close, it's okay. In the American system in football, we look for very detailed precision about what are essentially judgment calls. Right? My favorite example of this is instant replay. How many times will you sit down and watch a professional football game where they're taking a look at the replay to see, did the person have their feet in bounds or not when they caught the ball? And the people who are broadcasting the game, they respond, yes, there's no doubt he had their feet in bounds. And then, of course, the officials come back and say, no, we don't have enough evidence to show that the player's feet were actually in bounds when he caught the ball. Right? It's a judgment call. We like to be very precise and very detailed and look down a very micro level to determine something that is really ultimately a judgment call and ultimately does not have a whole lot of effect on the outcome of the overall contest. So we spend a lot of time, a lot of energy on things that are relatively meaningless in terms of determining the outcome of the game. We can draw these same comparisons with the criminal court systems. In Europe, they have a much more free-flowing process. There's not a lot of rules for when you can collect evidence or when you must present evidence. There are not a lot of rules for what evidence is admissible, what evidence is not admissible. Focus of attention is on the witnesses. They are the ones who are presenting the evidence to the court. Now contrast that to the American system. We spend a lot of time and a lot of detail on very small little pieces of the case, all in the name of establishing perhaps reasonable doubt or the constitutionality of a search or a seizure. And we're going to analyze this over and over again. And we're also going to put our focus on essentially the coaches, i.e. the attorneys. This is an attorney-driven process. It requires specialization. It requires understanding the ins and outs of the game. It requires lots and lots of preparation time, just like in football. And so you can see these parallels that exist within both the favorite sport of the country and in the court system of the country or continent. In the United States, we use what's called the adversarial process. And another law professor by the name of Gary Goodpaster in the late 1980s wrote an article called On the Theory of the American Adversary Trial. And he basically, to summarize or to paraphrase his idea, he said this is basically the theory underlying the American criminal trial. It is a regulated storytelling contest between champions of competing narratives composed from the same information and presented under significant constraints. Now, what exactly does that mean? First, at its very basic level, it says whoever tells the best story is going to win. Right? It's a storytelling contest. One side tells one version of the event, another side tells another version of the events. It also works from the assumption that both sides want to win. Again, think about a football game. If one team is playing another team and only one team wants to win, how do you think the outcome is going to be? Well, the team that wants to win is going to win, and it's not going to be much of a contest if the other team isn't trying. And so our adversarial system requires that both sides, when they're presenting their story, want to win. They also have to follow certain rules. Right? There are rules of evidence. There are ethical rules. There are procedural rules that everybody must follow. And that's what the rest of this video is going to look at, is what some of those procedural rules are and where do they come from. When we look at the criminal court process, we have to look at it not only in steps through the process, what happens first, what happens second, what happens third, but we have to connect it with the idea of rights. We in the United States have certain rights when it comes to trial, and a lot of those rights are procedural rights, so that they must happen. You cannot be convicted of a crime unless you are given these particular procedural rights. And they are all have originated from practice initially, but then when the Constitution was first amended in 1789 with the first 10 amendments, the Bill of Rights, the drafters included a lot of procedural protections for criminal defendants. And over time, those protections, the words that were used, have been expanded upon, have been added some detail to them, so that there is much more process today than there was 200 years ago when we were starting. And so what we're going to do is sort of walk through these rights and show how they connect to the different steps of the process. We're going to begin with the basic right of due process. No person, according to the Fifth Amendment of the Constitution, shall be deprived of life, liberty, or property without due process of law. Now, the question is, what does that mean? And that encompasses a lot of different things. The basic thing we have to understand is the amount of process that is due is going to vary from thing to thing. So if we're taking away your property, you get one set of process. If we're taking away your liberty, you get a little more process. If we're taking away your life, you get even more process as we go along. And so it's important to understand that there's not a uniform due process necessarily. It depends on what it is that the government is trying to take from the particular person. Now, in criminal cases, just about everything revolves around liberty, taking away someone's liberty. We're going to either put you on probation, we're going to send you to prison, and so that is depriving you of liberty in some way. And so we're going to focus on that due process protection, what due process is required to take away someone's liberty. The first requirement is the requirement of notice. Government has to tell you why they think you did something wrong. They have to give you notice of the charges against you. So they're going to file documents with the court. It's going to lay out a complaint and say that on this date, at this time, at this place, you killed somebody else through this method. It has to give sufficient detail so that we know it's not something that you've been found not guilty of already, so that it gives you enough information so that you can, too, defend yourself. We call this an arraignment. Generally, you will go into court on the first day after you've been arrested. The judge will tell you you've been charged with murder in the first degree, and then we'll go on to the next step. The next step is essentially bail. The Constitution guarantees that in all criminal cases, the accused shall have the right to a reasonable bail. Now the question is, what is reasonable? And that has changed over time, certainly. The basic idea behind bail is that we want to, one, ensure that you are going to show up for court. This court process, as we go from beginning to end, can last 2 years. Most cases, especially if they're going to go to trial, are going to last about 18 months to 2 years. So we will need to make sure that you're going to continue to come to court when we need you. The second thing is we need to make sure that you're not going to harm other people. Now, while there's a presumption of guilt embedded in this concept of protecting public safety by requiring bail, we also don't want you, if you've been accused of killing 5 people, to go kill 5 more while you're waiting this 2 years for trial. And so those are the 2 criteria that we use for bail. Is it going to ensure you return to court, and are we going to be able to protect the public safety? I just mentioned that this idea of bail creates a presumption of guilt. Why is that problematic? Well, our system requires that those who are charged with criminal offenses are presumed innocent unless and until proven guilty through a trial. And the prosecutor must prove you guilty beyond a reasonable doubt. If they have not proven the case beyond a reasonable doubt, you cannot be found guilty. So even if the jurors think the person did it, but they have some sort of reasonable doubt that maybe not, the person must be found not guilty. Even if it is more likely than not that the person committed the crime, the defendant must be found not guilty. That's essentially what the idea of proof beyond a reasonable doubt means. In order to file criminal charges, we must have probable cause. We talked about this a little bit in the introductory video. You must have probable cause for the judge to issue an arrest warrant. So what will happen is the police will gather up their information about the case, and they will present it to the prosecutor and or the judge. The judge or the prosecutor or both will review the case, and then will take it to a judge for finally issuing an arrest warrant. That, according to the Fourth Amendment of the Constitution, must be based on probable cause. It must be also either a grand jury probable cause determination or a preliminary hearing probable cause determination. So in some jurisdictions, the prosecutor can choose. They can take the case to a grand jury, which is a group of citizens who spend their time listening to evidence presented to them, and they decide if there is enough evidence for the case to go to trial. We call that an indictment. Or they can, prosecutor can choose to present the evidence to a judge, put witnesses up on the witness stand, have them testify, and afterwards the judge will determine if there's enough probable cause for the case to go to trial, and in which case the court will receive an information. stating the charge. Now, the big difference between these two things is the grand jury occurs in secret. There is no defendant present. There's no defense attorney present. The judge is not even present for a grand jury hearing. Whereas in a preliminary hearing, the defense attorney is there, the defendant is there, the defense attorney can ask the witness questions, the judge is going to rule on evidentiary issues, and the judge will make the determination. So those are the two big differences between a grand jury hearing and a preliminary hearing. Once probable cause has been determined, the defense has the right to receive all exculpatory information from the prosecution. What that means is any information that would tend to show the defendant is not guilty of these crimes must be given to the defense attorney. This is not in the Constitution itself. It was decided by the United States Supreme Court in a case of Brady versus Maryland. And then it's been expanded upon over the years through court rules, where prosecutors now must give all kinds of information to the defense, including witness names, including lab reports, including the actual physical evidence that's been collected. All of these things must be disclosed to the defense prior to the trial beginning. And now the defense also has some reciprocal discovery obligations as well. If they're going to rely on an affirmative defense, such as insanity, alibi, they must disclose those witnesses or any other experts that they're going to have testify at the trial as well. Defendants also have the right to a fair and impartial judge. You can't have a judge on this deciding your case who is biased against you. So if you have a judge who is, let's say, racist and has an African American defendant in front of the judge may intentionally rule against that defendant simply based on race. That is impermissible. It is not a neutral judicial decision. Therefore, the defense has the right to request a different judge. Likewise, the prosecution, if they feel that a judge is going to be biased toward a defendant, can also ask for a change of judge. Defendants also have the right to a trial. And we'll talk about what that trial looks like in a few minutes. But they have a right to that trial in the district where the crime occurred or the location where the crime occurred. That trial must also be conducted in a manner that's fair and impartial to both sides. The Constitution gives defendants the right to trial by jury. And so the Supreme Court has said that as few as 6 jurors are permissible. Most every state, though, uses 12 jurors. They must be drawn from the community where the crime occurred. They must reach a unanimous verdict. All 12 or all 6 or whatever number in between those two are used. They all must agree that the defendant is guilty prior to rendering a guilty verdict. Defendants have the right to confront witnesses against them. This means that the prosecution must put their witnesses up on the witness stand, and the defense has the right to question them about what they saw, what they heard, what they remember from that particular incident that the defendant is charged with. A defendant has the right to remain silent. The court, the jurors, cannot use the defendant's choice to remain silent as evidence against the defendant. While people naturally want to hear both sides, they have to be able to say they will not hold the defendant's silence against the defendant when they are reaching a verdict in the case. Conversely, the defendant has the right to testify. No one can take that right away from the defendant, and so if the defendant chooses to testify, the defendant has that right. Now, once the defendant testifies, the defendant is treated just like any other witness. The same rules apply. The prosecution has the right to cross-examine and question the defendant as well. The defense also has the right to call its own witnesses, and if those witnesses don't want to come to court, the defendant has the right to ask the court to order those witnesses to come to the court. And if they still won't come to the court, they literally can send the police out and arrest those witnesses and bring them into court. Right? So the defendants have the right to compel witnesses to testify on the defendant's behalf. If the defendant is found guilty, the defendant has the right to appeal. So the defendant can take from the court of original jurisdiction, remember we talked about that in episode 2, and appeal to a court with appellate jurisdiction. If the defendant is found not guilty at trial, the prosecution cannot bring the case back. You have the protection against double jeopardy. So once you've been found not guilty, even if the judge made errors, even if there were clear errors made during trial, the prosecution cannot take the case to the Court of Appeals and ask if they overturn the not guilty verdict. A not guilty verdict is absolute. And then finally, throughout this entire process, you have the right to have an attorney with you. You have the right to counsel at every critical stage in the process, whether that is arraignment, whether that is bail, whether that is preliminary hearings, whether that is motions for change of judge or change of venue, whether that is the trial itself. You have the right to effective assistance of counsel at each step in the process. Now, 98% of criminal cases do not reach trial. Most of them are resolved through plea negotiations and guilty pleas. A person is able to plead guilty if they do so knowingly, voluntarily, and intelligently. What they're doing when they plead guilty is they're giving up all of those rights that we just went through, and they're agreeing that they are in fact guilty, and they're going to accept whatever sentence they've either agreed upon or the judge is going to impose. When we talk about a defendant pleading guilty knowingly, they have to understand that they're giving up these rights, they have to have that comprehension, and they have to know what the consequences are when they're pleading guilty. Guilty plea must also be done voluntarily. It means there cannot be any threat, there can't be any coercion. Of course, the one exception to that is the plea offer itself. So if you are looking at a 10-year sentence, if you go to trial, the prosecutor offers you 2 years in prison to plead guilty, right? That is, to some extent, coercive. It's getting you to plead guilty by shaving 8 years off your sentence. That is not what we're going to consider involuntary. Instead, if I was holding a gun to your head, that would be more what we're talking about in terms of coercion or involuntary guilty plea. Finally, it must be done intelligently. In other words, there has to be significant evidence against you. Right? It has to be done based on a statement of facts given by the prosecution that the defendant will agree to and admit to and say, yes, I did this, and those facts must constitute the crime with which the defendant is pleading guilty to. Now, if the defendant's not pleading guilty, if the case is not going to be dismissed by the prosecutor, then we're going to have this jury trial. And this is where the storytelling contest comes into play. When we have these trials, we can have either a bench trial or a jury trial. The defendant has the ability to decide which the defendant would prefer. There is a waiver of rights that goes along with waiving your jury trial, but a bench trial would occur before just a single judge. Those trials tend to go a lot quicker. They tend to be a lot less formal because there's no jury there. The judge is going to be both ruling on the law and determining the facts and the outcome. Whereas a jury, you have a lot of extra steps that go along with the process, and the jurors are not necessarily legal experts like the judge is, so you need much more explanation that goes with each of those witnesses that may testify. Assuming the defendant elects a jury trial, the case is going to begin with jury selection. Right? Both sides have the opportunity to question the potential jurors, and they can remove jurors for one of two reasons. They can remove jurors for cause, meaning that the juror cannot follow the law, or the juror is biased towards one side or the other. The attorneys can also remove potential jurors peremptorily using peremptory challenges. These are jurors that can be removed for any reason except for their race or gender. Both sides get a limited number of peremptory challenges. As the attorneys finish that process, they are looking for jurors who are going to be most receptive to the story that they are telling. So if the prosecution is telling a particular story, they're going to look for jurors that are going to be responsive or going to be able to identify with that particular story. They're going to remove jurors who may not understand that story or may not identify with the particular story that they're telling. In addition, during the jury selection process, when the attorneys are asking questions, they are dropping hints about what that story is going to be. So if I have a case where I'm concerned about police credibility, I'm going to be asking questions during jury selection to make sure the jurors know that police officers are treated just like any other witness. They're not given any more credibility because they're police officers. They're not given any less credibility because they're police officers. But that the jurors may take into consideration things like the police officer's experience, their ability to observe, familiarity with different types of crimes. All of these things can affect the jurors' credibility assessment for those witnesses. And so, as one of the attorneys questioning, I'm going to be asking questions about that. Once the jury is selected and put together, the jury is going to be sworn. And this swearing in is really important because it establishes when jeopardy attaches for the purposes of double jeopardy. Remember, we talked about the fact that once a person is found not guilty, the prosecution cannot bring the case back. How do we know when that trial begins? The courts have said that it begins once the jury is sworn in. So if the prosecution would dismiss the case after presenting a couple witnesses, the prosecution cannot bring the case back. They would be barred by double jeopardy. Once the jury is sworn, the prosecution will present its opening statement. This is basically the prosecution's opportunity to summarize and introduce the jury to the prosecution's story. They're going to talk about a theme to the case, they're going to talk about the theory about why the defendant is guilty, and they're going to tell the jury what the basic facts are in the case and who those witnesses are going to be. Once the prosecution is done with their opening statement, the defense has an option. They can give their opening statement right away, they can reserve their opening statement until after the prosecution has presented its case, or they can elect never to give an opening statement. This is purely the defense option, and it's based in that right to remain silent. The defense doesn't have to give an opening statement. They don't have to present any evidence throughout trial. It is the government's burden to prove the case beyond a reasonable doubt. As a result, the defense does not have to do anything during the trial. After opening statements, the government will present what we call its case in chief. They must call their first witness. That witness is going to be asked questions by the prosecutor. They are going to be what we call direct examination questions. They are open-ended questions designed for the witness to tell the witness's story. So it may start with the witness's name, where the witness was at the time and place in question, how the witness got there, what the witness observed. Once the prosecution is done asking the witness questions, the defense will have the opportunity to ask questions. These are more close-ended questions, which are leading questions. They are questions that are designed to suggest the answer to the witness. It will be questions like, you were at the park on this day, weren't you? It was 2 o'clock in the afternoon, weren't you? It was a cloudy day, wasn't it? These are questions that are suggesting the answer and limiting the witness to yes or no questions. As you can see, the big difference between direct and cross-exam is the witness is the star on direct exam, the attorney is the star on cross-exam. Both the prosecution and the defense, through their questions, are trying to communicate their story to the jury. The questions are designed to begin telling that story to the jurors. Once the prosecution has finished with its first witness, it will go on to its second witness, its third witness, its fourth witness, as many witnesses as they have, and it will proceed in the same way. The prosecution will ask questions first, the defense will ask questions second. There is also the possibility of what we call redirect examination and recross examination, where the prosecution and defense will ask the same witness additional questions based on what the previous questioning revealed. Once the prosecution has completed all its witnesses, the defense has the option to present its case. They can present witnesses if they so choose. The defendant can testify if the defendant so chooses, and it will proceed, if they do call witnesses, just like the government's case. The defense will call their witness, the defense will do direct exam, the prosecution will do cross-exam, and they'll keep working through that process until all the defense witnesses have testified. After that, the two sides will get together and they will meet with the judge and they will come up with the jury instructions. This is a series of instructions that are given to the jury that state the law of the case. They're given some basic instructions in terms of how to assess the credibility of witnesses, what rights the defendant may have, the fact that the defendant did not testify, it can't be used against the defendant. But one of the key instructions is what we call the verdict director. It will list out the elements of the offense. When we talk about the elements of the offense, we're talking about what the government must prove beyond a reasonable doubt for the defendant to be found guilty. When these elements are identified, they become the basis for the theory the prosecution presents, and it is what the prosecution is going to emphasize in its closing argument, and the defense is going to use as a means to show how there's reasonable doubt as to one or more of these elements. Once these jury instructions have been prepared and presented, the two sides will give their closing arguments. Generally, the prosecution will go first, the defense will go second, the prosecution then gets to give a rebuttal. Both sides have an equal amount of time to present their evidence or their closing arguments, and so if we have a 20-minute closing argument, we may have 11 minutes from the front side for the prosecution, then the defense will go for 20 minutes, and then the prosecution would go for 9 minutes in rebuttal. Once the arguments are finished, the jury is going to go deliberate and then render its verdict. Verdicts are rendered as what we call general verdicts. They're given guilty or not guilty in terms of the outcome. We never find out the reasons why the jurors decided the way they did. And ultimately, the outcome rests on who tells the best story. Research shows that as jurors decide cases, they're putting together a story in their own minds, and as they weigh the two competing stories, they try to figure out which story best fits with this story they have in their own head. And so that's why telling a story clearly and one that's going to resonate with the jurors is so important. So that wraps up the criminal court process. We looked at sort of the theory behind it and the adversary theory. We looked at the steps and the rights that go with it. And then we looked at how this storytelling contest plays out in the courtroom. Our next episode will take us into detail about who prosecutors are, what do they do, where do they come from, as we begin to finally dig down into the prosecution environment in the prosecution world. Thank you for watching. We've asked that you would subscribe to this channel if you like this series. We will have other video series coming in the near future. In addition, you can hear us on our podcast, the Politics of Prosecution Podcast. It's on iTunes and Spotify. You can find us on Instagram at POLI_N_PROS. You can find us on Twitter at POLI_PROS. Again, thank you for watching. and we look forward to seeing you for our next video.